Hello, ladies and gentlemen. We are back with the SAPI IP Business Talks. This time we talk about AI in legal tech. My guest today is Adam Novak. He will explain us about his background, how he came into that field, and for the moment, AI is the big shaker in the IP field. We have to take into account that we have to deal with it, and Adam is one of the front runners in that field, and he can explain us what's going on there. And I'm very, very curious to learn more about this interplay also with patent attorneys, with state of the art retrieval, so all that kind of things, which are, yeah, some say under pressure of AI, others says we have huge opportunities with AI now, and definitely it is the topic which we have to discuss in these days, and we do that today, so to speak, again. Adam, thank you very much for joining us in the SAPI IP Business Talks. First question to you. By the way, ladies and gentlemen, we are live, just this housekeeping thing. We are live on LinkedIn. So when you write questions in the chat, we are happy when you do that, and we are happy to take them, to bring them into our discussion when you want to be you feel invited to do so, and we are happy to integrate you in our discussion. So, Adam, thank you very much for joining us here in the SAPI IP Business Talks. My first question to all of my guests is always the same. How did you came into that, to a certain extent, strange field of IP?
Okay, perfect. Well, hello everyone. Thank you, Professor, for the introduction. Very happy to be here as well. How did I come into this field? That's a great question. I'm a bit of an outlier because I don't formally have a background in IP and legal. My background is in economics and finance and software building. So I come from that direction, from that flow. And so it all started several years ago in 2022, 2023, when I participated in the European Patent Office hackathon on green plastics. And the idea there was to create a patent retrieval system to improve the current patent retrieval system offered by the EPO, by the European Patent Office. And we had an interesting idea that basically all the softwares are currently based on usually keywords or inputting a description into a search field, right? Well, we thought, why don't we try to turn things the other way around, try to turn them on their head. Instead of a person inserting a description into the search bar, they provide a small description, and then the software starts asking them questions, slowly, one after another. And based on the responses that we receive from the user, we continuously update the patents that we find during the prior art search. So that was the basis for the technology that we've created. And then we combined that with the fact that we noticed that marketing opportunities and brand building opportunities for patent firms and patent attorneys are quite limited. And I think that's why what you're doing in the IPBA is fantastic, and you understand that very well, that the importance of brand even in this traditional sector, in this business. So we try to combine that and to create this client intake software for patent firms. And that's exactly how we ended up here in this place.
Yeah, I got you. Fascinating. I mean, the studio because we had a meeting, and in that meeting we discussed a new master program for IP management. The question, what should be in it, and what all the guys from the university, from the offices, all are involved here, who are involved, said we need more financial understanding, more valuation understanding, not just patents, also branding. So it is really, meanwhile, it is common sense that that these kind of topics are absolutely relevant and crucial, and that not every problem is a patent just because somebody is a patent attorney. So obviously the IP world needs brilliant, well educated, well-trained patent attorneys, but the broader picture is also extremely important. And what also turned out in that discussion is that the value of IP is seen everywhere. Meanwhile, so even in for startup companies, and
absolutely.
yeah, and the question which I have is, so my feeling is that also startups say, yes, IP, especially patents, are important. We have to deal with that. We have to think about that. But then the barrier, the hurdle, really to contact a patent attorney and say, look, could you look that through? Could we discuss with you whether there is something invented maybe, or can we describe it as an invention? This hurdle is relatively high. At least startups see it like that. Okay.
Yep.
So the question is, when we want to encourage startups to think more about IP, patents especially, what can we do to support them, and so to speak, to make the interface between startups and the patent system here, the patent attorney, to make this interface more efficient from the very start, when this first contact should be initiated? What do you think about that?
Exactly. Right. So I don't want to sound like a broken record, but the barriers to entry in the IP industry are, they're mentioned quite frequently in many different posts and many different calls, many different talks. And it's that the IP system is, and patent attorneys know this, is quite complex, and there's quite a steep learning curve in the beginning. SMEs and inventors don't know where to start from, right? They hear about the importance about IP rights. They understand that if they're a startup, many VCs ask how their invention is protected, if they have a patent, if they have some sort of IP strategy in line. But they don't know if they need to do a patent search, freedom to operate search, how many jurisdictions they need to file patents in, whether they even need a patent in the first place, or whether a provisional patent application is fine, which is a controversial topic. Some people say it's better not to do it. Some people say it's better to do it. And once they finally figure this out, and they have to choose a patent attorney, and to a person who's never done this before, the websites of different patent attorneys can look fairly similar. The services that they offer can be quite similar, and it's hard to differentiate which one they go with. Usually, it's based on a referral. If one of their friends said that they had a great experience with this patent attorney, that's what that's the person who they'll end up going with in the end. And lastly, there's of course the question of the costs. I don't think it's so much the absolute number of these costs, the quantity that you have to pay, because at the end of the day, it's an investment into the profitability and sales and innovation of your company. But what matters is the transparency of the costs. So patent attorneys can be transparent with you about how much their services cost, but the cost to obtain a patent can be a bit difficult to estimate based on the filing fees, administrative fees, and things that come after. And so how can these barriers to entry be lowered, right? I think what's already being done is the traditional methods are fantastic. Organizing workshops and events to discuss the ins and outs of the IP industry, and establishing the direct contact and communication helps build the trust and the comfort so that a company can then proceed with their patenting journey. But at the same time, I think that offering digital tools to people so that they can experiment, play, and slowly get familiarized with the IP system by themselves is also very beneficial, and which is what we as a company are trying to do. So existing patent search tools are great, but they can have a bit of a steep learning curve as well. You have to sort of understand the structure of claims and the different CPC classifications and things like that. So we've built an easy-to-use patent search system that asks you questions about your invention. Sorry?
Even the structure of patent literature, I said even the structure of patent literature itself is complex, and
exactly.
Sometimes creates a certain hurdle just to start with it. So you are overwhelmed, impressed, and it's simply when you see the first time a patent document, you say, and then when you start to read it, you say, I will never ever understand what's going on there. So the formal aspects, the technical aspects,
Yeah,
the
exactly.
content-wise aspects, that is all separating the tech world, the startup world from the IP world, right?
Yeah, exactly. Yes, exactly. So what we're trying to do as a company is to become basically the first digital point of reference for companies and inventors that want to patent something. It's an easy introduction onboarding process into the IP industry. Using the software, we then guide them through the essential first stages, patent research and novelty check. And then if they're happy with the experience, then we connect them to a patent attorney. And I think this is what digital tools should be used for in the IP industry. It's not to replace patent attorneys because what they do is a very specific and talented job, and it's hard to recreate it through some sort of digital process. But the idea is to slowly guide and introduce people and onboard them into the IP process.
Okay,
Exactly.
so what I understand is you want to make it more attractive, more easier, reduce the hurdle, reduce the barrier
Yeah,
for startups to come into that field of IP, to familiarize themselves with IP. So,
exactly.
I mean, there are people out there, we have to talk about that. They say the IP system is for good reasons so complex. And when you reduce the complexity, you make mistakes. This is misleading. So I think AI is a game changer in that direction. But what comes into my mind is when you say, so what you're doing, you you offer a retrieval, an answer to a question. So how should I understand these lowering of the barrier for example, startups?
So how should you interpret the lowering of the barrier? I think if you lower the barrier, you can lower the barrier by building a sort of, it's important to build trust with the user, with the startup in the beginning, with the company that wants to become a client. That's the first essential step to lowering the barrier and making people feel more comfortable with going onto their IP journey. Because the IP business, at the end of the day, it's a heavily trust-based business. And to build trust, you need to have constant contact in one form or another with inventors and SMEs. At this day and age, I think it also means having contact with inventors and SMEs online as well, and being able to establish that contact directly online instead of waiting for them to come you. And it's sort of building this trust, starting to build this trust online. I think one company that does this very well is a Swiss company called a Swiss law firm called Lexer. They offer simple digital contract templates online that people, when they come to visit on their website, they can download. So like founders agreements, investment agreements, things like that. Even though these contract templates might not be their best work, they offer them, of course, for free. The good stuff, of course, you have to pay for it. But still, it creates this first trust-based relationship. It lowers the barriers for then the startup to then come into contact with Lexer and then become one of the clients. They say, well, Lexer gave me this small digital service. I might as well contact them and see what else they can offer me and see if there's opportunities to build a relationship. And we talked to Lexer, this law firm from Switzerland, and they said that this digital presence, this digital tool contract tool that they offer to the clients, has helped them a lot to increase the sales and number of clients that they've gathered over the months.
Okay, I mean that is basically content marketing, which so the web page is a certain interaction point, and you create trust by offering certain content, right?
Yeah, exactly.
So that is what the Swiss law firm is doing.
Yeah, exactly.
And okay, and so, but the law firm would then argue and say, "Naya, for us, this is a huge effort, or this is an effort. So why should we do that?" And especially when it is more individualized, this kind of support. So then the costs go up for the patent attorney to create this trustful relationship. And now we have tools which could help here. what can these tools do? For example,
Okay.
what you develop.
So what we do in a sense is we like to think of, so since the patent industry at the end of the day is a business, and businesses run on metrics and KPIs, we also like to think of KPIs. So we've interviewed several patent attorneys in Switzerland, and we asked them about their customer acquisition costs. So how much the time, non-billable hours, money they have to spend on acquiring a new client. And the number came up technically quite high, between 3,000 francs and 5,000 francs just per client to acquire a new client. We either go into conferences, discussing with them, emails back and forth, calls, things like that. And um, what we did in our case is we built a tool to try to lower these customer acquisition costs. It's sort of a automatic digital legal intake funnel that we embed into the website of our patent firm clients, so that this tool can automatically intake new visitors from their website, have them do a patent search, and so that they have basically an interested person that came on their website basically in a database for them. So they know that this person came here, try to do a patent search, and is potentially interested in continuing this relationship. And already basically you have a lead who you can potentially validate and consider pursuing a commercial relationship with. So although it might seem as though they're increasing their costs by offering this software, for example, in Lexer's case, it may seem as though they had to invest time and money into offering the service to the potential customers. At the end of the day, since more people will come on their website and interact and engage with the website, it actually has the effect of lowering the customer acquisition costs in the long term.
Okay.
And that is the principle on which we work with. Yeah.
Yeah. So you argue now pretty much in a marketing world, in a line of thinking. So we have customer acquisition costs, we have a client journey which we have to take into account. We want to create trust with content marketing. So that are pretty. So I'm working a lot with patent attorneys and lawyers, and quite often I don't have the feeling that they really think in that way, like
Exactly, yeah.
like software providers or service providers, right? So lawyers or attorneys are pretty much more thinking in that. So I'm running a private practice, and when somebody wants to come to me, it's fine. So they even have issues with personal branding or expert branding, and also these client journey discussion is sometimes for them, let's say, quite strange, or they are not familiar with that. So how can you convince law firms that these digital presence, these creating in the digital space trust, and that such a tool can help with that? How do you communicate with them? Is it that you explain the whole issue of content marketing and client journey orientation, or you just focus on the tool?
Absolutely, yeah. No, I completely agree with you in that regard. So during these interviews and discussions we've had with many of our clients and patent attorneys, when we ask them to calculate their customer acquisition costs, right, sort of focus on the marketing and business side for a couple of minutes, they get a little bit surprised when they can't provide an immediate answer to the question. So they have to think about it. We have to guide them through the questions. How many events do you attend? How much do you pay per event? If you use any marketing tools already, how much do you pay for them? So it's not really a metric, a number that's already in the back of their head, unlike in other businesses, for example, I don't know, finance or e-commerce, online businesses that really focus on these metrics. And so what usually happens is, once we start talking about the marketing and business side of things, we've seen this reaction in our clients and the patent attorneys we've talked to. They start thinking about more and more basically this aspect of the business. So mostly they're focused on the technical aspects, but now that we start this discussion, they start considering these aspects more, right? How many visitors do I get on my website, or do I need to build a brand on LinkedIn online? And usually what we do is we talk about use cases. So we explain to them the customer journey, right? They focus mainly on customers that are already come to their website and already come into contact with them, right? But what we try to explain to them is that there's you as a patent attorney in a trust-based business, you can build more trust by sort of extending your hand also into the digital realm and starting to build a presence there, sort of. And with our tool, for example, they can do this automatically. Basically, they can say to their users, we offer you a free patent search and novelty check. Come on our website and check it out. And basically, with this, with something as simple as that, you can see who came on your website. You can see if there's been interaction. And so it's about the way I like to think about it, it's about translating clicks, online clicks, either on LinkedIn, on your brand, or on your website, into engagement and then into clients. And the more clicks you generate, the more engagement and potentially the more clients you have, especially these days when I think digital presence and the digital world is becoming more important, even in an industry as traditional, in an industry which is seen and perceived as traditional and conservative, like the IP industry. I think there's a lot of technological progress being done in this case, but the way people perceive it is still a bit very traditional.
Yeah, I mean, we had a wonderful meeting in November in Norway, and the president of the Norwegian IP office said it is fascinating that a branch which is always talking about the latest innovation or inventions is seen itself as such a conservative branch. But on the other hand, what we see is that this is changing dramatically, and that lots of law firms now want to be seen as front runners, want to be seen as the ones who really offer the latest technology to their clients, simply because they look for differentiation. And just having big offices and expensive carpets or whatever is not what the next generation of decision makers are looking for. So what they want is a certain service level, and they simply expect from their law firms also to understand these tools, to help with that tools, and to improve at the end of the day for the euro or for the Swiss franc. They should improve the service level. I guess this is the point. And so what we observe is that is that true? Do you see that in the same way? So that when patent attorneys don't have to explain all the basics again and again, because they offer that on web pages, or they have already trainings established, or they can even offer a free of charge state of the art research, so that they then have more time, more interaction on the more strategic consulting questions with their clients, which has a much higher value compared to just explaining the basics. So how do you see that?
So it's a bit of a tricky question, because there's definitely tools out there, patent search tool or market intelligence tools, that can really make the work of patent attorneys faster. But they're not cure-alls, but they can improve the efficiency. They can decrease the time that they spend on the work that they do. But I think that still the initial stages of interaction with a client and explaining the way the options that they have for patenting and the benefits of patenting is also an important part of strategy consulting. Because a patent tool can tell you, right, this invention has already been patented here. its novelty cannot be proved because it's been patented in this jurisdiction and blah blah blah. But the role of a patent attorney is then to come and say, okay, these are the facts. Let's think of strategies around this. Let's think of the way we can maybe still provide you with the IP rights for your invention and potentially focusing on a different feature or aspect of your invention. And so I still think that initial interaction with the client in the beginning to explain the workings of the IP industry is very important. But of course, if patent attorneys want to save on the time and money on the interactions with the client in the initial case, there's some things that can be of course provide to basically save on this time and money. One, for example, is maybe to provide more transparent estimates of patenting costs, right? So as mentioned before, patent firms have they'll probably have specific prices in mind for the services that they offer to the clients, but there's also additional administrative fees, renewal fees, infringement fees, and prosecution fees that have to be taken into account by the client when deciding whether to patent something or not. So using tools like this can already, I think, filter out a bunch of potential clients who are not comfortable with the cost that they would have to pay for the IP rights of their invention, and this saves time for patent attorneys on the validation that they would have to carry out with this initial client. Also, there's another interesting tool, market intelligence tool called IP Pilot that I've ran into. What they do is they basically analyze a lot of patent data, and they really focus on patent statistics and also who filed the patent. So the company, but also the patent prosecution person who prosecuted the patent attorney, basically. And so they provide statistics on filings across jurisdictions, which patent firms have more success in which jurisdictions, who are their main clients, and so on and so forth. And by using sort of this information, I think this is more geared towards larger firms, because smaller firms will probably not need it as much. But larger firms can use these tools to understand, get a better feel and understand with which patent attorney they want to collaborate with, which patent firm, and in which jurisdictions they see maybe which jurisdictions they feel more comfortable in, and in which they should file.
Yeah, got you. So, but just to stay a little bit on this focus shift. So I got you that obviously to establish this trustful relationship, you need an exchange of information, and also the basics are relevant. Then you mentioned the transparency, and sometimes this is really frustrating for the users of the IP system, that this system is so complex that quite often it is not a bad will, it is simply impossible to really forecast the costs for a certain patent. And we don't talk about enforcement, it is just also the prosecution can be very different depending on the reaction of the office and the complexity of the patent. So how do you think, and the same thing is with AI, so that AI is not really transparent in terms of why is this or that decision made. So what we hear from time to time is that we add up intransparencies. And to which level do you think that AI can help to generate more transparency in the system?
That's a very interesting question. So yeah, I like the idea of how you mentioned the intransparencies build up, and it just makes the system more complex, continuously more complex and more complex. And of course, if you want to use AI tools to sort of, or legal tech tools to sort of decrease this intransparency, make the system a bit more transparent, you also have to be cautious with the results, of course, that the software, that the system that you're using provides you with, right? And So I think in this case, what's important, I like to think of it in terms of like the the international relations model. I think I don't remember who said it, but trust but verify. I think there has to be always a patent attorney, or at least a person with extensive IP experience, pretty much, not at every single stage, but at every crucial stage before, at every crucial stage after which a software tool or an AI tool is used to trust, but also verify whether the output that was produced can be used on. As I mentioned, the tools that we're seeing now, maybe in the future they'll be different, but they're not a cure-all. They're basically an addendum, an additional way to make certain parts of the process more efficient and make them take up less time, to help the patent attorney maybe get a more broader vision of the current patent space and things like that. But every single output that is created by a tool, I think, should be verified by a patent attorney. Of course, you will never file something that's been drafted by some AI tool just like that without checking. And it's important to do it at key stages. So, for example, after a patent search, the results that are provided, a person with IP experience should look over the results and see if the results provided are completely irrelevant, or they're spot on exactly in the area in which the invention is focusing on. And that's sort of exactly the point that we're trying to do with our software, right? So our software asks the user questions about the invention. The user responds. So the user is the one in control pretty much all the time, provides us with a response. We take that response into account and then update the prior art that we find. And in our case, the user is always in control. He can say whether this patent is relevant or irrelevant, or based on, or change his answer so that the results that we show will be different in the end.
Got you. So, so it's a chat, right? So the user can chat with the on the web page from the law firm, can have a chat with the state of the art about the invention. So is the invention then disclosed? So is that then given to the public?
No. So in our case, privacy is of course quite an important aspect in the IP industry. Of course, invention disclosure can ruin the improper management of invention disclosure can ruin the novelty of an invention. Can screw up very much the IP rights of a company for their innovative product or system or service, right? So what we do in our case is all the data that is inserted in our website is stored locally with us on our private servers, and so we don't rely on third-party systems for anything. So anything that you input into the system is stored secretly on our database and in our service that we host locally in our office. Then on top of that, we also provide the opportunity for a user to sign an NDA with us on top of that, to also provide sort of legal enforcement of the novelty of the invention, so that if the invention is disclosed, then we will have to take the blame on ourselves in the off event, in the unlikely event that the invention is disclosed. And also, lastly, we will never really ask you to state what is new in your invention. We won't ask. So the chat will never ask what is basically the innovative aspect of your invention. What we always what we always do is we compare and contrast existing patents with your patent. So we basically compare if the features are contrasting or if they're aligned. And in that case, you never really disclose the innovative nature of your patent. You just sort of see in which ways they're similar and in which ways they're different. And maybe as a side note, there's also interesting work being done on encryption, something called homomorphic encryption. It's a bit of a side note, but it's a way to always have the data encrypted. Even the model will work on encrypted data. Even the AI model will work on encrypted data. That's, I think, an interesting direction being done in the technological field. And I think the worries of many patent attorneys about privacy and security, if this homomorphic encryption technology is developed more, it will make certainly a lot of patent firms feel more at ease if it's implemented.
Yeah, got you. So another issue. So okay, there's this tool, this AI search tool, or this chatbot about state of the art, which I can use on the website of a patent attorney, to reduce the the burden of the first contact. I can just talk with the chatbot and to evaluate to a certain extent for myself what's going on here. And but definitely, so especially when the tool is good in what it's doing, so then these state-of-the-art information, which is digged out from the tool, is there is a certain disclosure of patent information, which is associated with the invention, and that could be seen as prior art, and some patent attorneys could, for the novelty of the invention, assume there is an invention in it. So how can a patent attorneys use these digital tools safe, and be sure always to process more and more information which coming up with such tools?
Well, as mentioned, it's important to use the right resources, right? So you don't want to rely on third parties that you don't trust. Maybe a third-party model provider, a chatbot provider that you don't trust, or to connect to or to send sensitive information online through servers that you don't trust, and things like that. So that's legwork that should be done by the patent attorney, by the patent firm beforehand, and to really make sure that any information that is being inputted online is can be safely stored and will be secured there. Secondly, another way to do this is, as we mentioned, you provide basically a very basic description of the patent right to see the state of the prior art. But the idea is never to reveal the novelty in the invention. You write a basic description of the invention that you have in mind, but never really disclose what makes it new, innovative, and different. And then with such an invention, then you can then ask these tools to compare and contrast to existing prior art. And although it won't really tell you specifically that whether this invention is novel or not, it can tell you where to focus a bit more on. It'll show you that these patents are similar in this case and they're a bit different in that case. And that there you know that you can focus on these 3 or 4 patents or 20 patents on top, so that you can save time by not reading the other patents that are clearly shown to be completely different compared to this patent.
Okay, got you. And that means, when I understand you correct, you could also use such a tool in an ongoing development process, so that you from time to time check what is the latest state, and that you compare that. Let's say 4 weeks ago, there was nothing really new, let's say, or that it matched a lot with other patents, but now we changed the development to a certain extent, and we see now more and more, or less and less documents have this kind of similarity, and that means our exclusivity in our solution becomes bigger and bigger, and that could be also because it is not that time consuming and it is extremely cheap or costs nothing, that can be really done, compared to the good old situation that everybody knows, that we have to take care about state of the art, but nobody is really doing it because simply it is too expensive.
Exactly, yeah. So that's what's neat about
Is that an intended use of the tool from your side?
Yes, exactly. So the point is that the database that we use underlying that we keep locally is always updated, right? Every time the APO or another patent office releases the patents, we update the database, and you can not restart, but as in start from where you left off last time by continuing answering the questions, and then you'll see that the results that pop up for the patent search will be updated, and potentially a new patent that wasn't existing in the database before will show up. So that's what's neat about it. Yeah, you can start off where you left off, continue the process, and be in like this consistent and continuous check of state of the art, as you mentioned, which is an important aspect in, of course, in the business that we work in.
Okay, got you. And that could also be used by a startup. And so this is again something what AI is doing. It is a democratization of access to technology. And here we can really see such an approach that you give that to law firms, that they can put it on their websites and that simply make it available to everybody. That is also a kind of democratization of the access to patent documents, and maybe that is much better than compared to what Google did some years ago with Google Patent, that they more or less copied classical search tools, and it was really hard to work with it when you have on your own no idea how patent documents are structured, and there we had exactly that pitfall, that the quality of the results was quite bad, not because the patent document were not available or the search tool itself is bad, but the knowledge which you need to use the tool was simply not given. And here with the AI we could overcome that kind of bottleneck, right?
Yeah, I think it's interesting to mention that so you have to know the person who you're dealing with, who the user of the software will be, right? If it's a startup and SME, they will, and they don't know the IP system so well, the IP industry so well, then they won't know to look into the claims. They'll be thinking in terms of invention descriptions and in terms of abstracts, but the real sort of novelty and infringement cases have to be looked at in terms of the claims. What is precisely being protected by the invention? So I think basically Google Patents spoke a different language when it came to startups and SMEs, right? They're thinking in terms of abstracts and invention descriptions, whereas Google Patents covers keywords, and you have to look into the claims to understand whether the patent is novel or not, right? What we do is we try to turn it around, right? We try to speak the language of startups and SMEs, get on their level. They provide us with an abstract and invention description, and then we go on and search through all the data for them, including claims and invention description.
Okay, so thank you very much for these last words. We have here on the blog of the IP Business Academy, we have also discussion and a post here. So for the ones who are interested, what is the patent law firm perspective? What is the startup perspective on the solution from Incatalyst? Can check that here, and obviously we will also publish much more content over the next weeks and discuss that also with law firms, and I'm very happy for that cooperation. So Adam, thank you very much for taking the time coming to the SAPI IP Business Talks. To the audience, thank you very much. Enjoy your Tuesday, and we are happy when we are back with the next IP Business Talk.
Thank you, Professor. Have a nice day. Bye-bye. Ciao.